I will briefly show you the EPO approach on, as probably you know, as we do it, even like that here. We have two consecutive legal requirements, as in most jurisdictions, also like in the US. We have a first legal requirement. This is the eligibility, or is it technical? And what we developed in our approach and via case law of Board of Appeals over the past 20 years or longer is a very stable approach. And we can say today it is easy to fulfill. It's easy to fulfill because most applicants know it, and most applicants foresee provision at least to overcome it. The legal test is very simple. It means, does the claimed subject matter have a technical character? And if it has a technical character, then it is eligible. The second requirement is more difficult, but not more difficult as for any other invention, because it means that the claimed subject matter must be novel and it must involve an inventive step, as every other inventions. So what is the problem? There shouldn't be a problem. However, when we say a claimed invention must have technical character, we speak about a computer-implemented invention, and we speak about the so-called mixed-type inventions, which have technical characters and non-technical characters. Easy, as soon as you have a technical character, it's eligible. So it means that all exclusions from patentability do not apply anymore. When it is technical when it is implemented on a computer, because a computer is what? It's technical. An algorithm is technical when it causes a technical effect. Then you even can have a claim directed to an algorithm per se. It's not anymore a mathematical method, it's technical. So cryptography, just the algorithms, is technical because it's used for securing a connection or securing devices. So this is very, very, very easy to overcome, at least by way of amendment when your specification is complete. So the first tip, basic tip is, please have always sufficient technical basis in your application. Patents are for technical inventions, therefore there must be technical issues and things in it. The limit as such, we said eligible computer, a computer-readable medium, a computer-implemented method of. That seems to be very, very, very easy for the first hurdle to overcome. To have it graphically here in a better way, what is the examiner doing? He's doing a search according to prior art, and we take here the closest or the nearest piece of prior art. So this takes away already a part of the invention, and then another part of the invention the prior art does not take away, might be of a non-technical character, let's say a financial transaction or whatsoever, and then there is a part remaining which is of technical character. If there is no part remaining which is of technical character, then it will not be inventive. If there is a part remaining which has a technical character, then the question is, which technical problem is solved, and is the solution of this technical problem non-obvious to a person skilled in the art? And if it's non-obvious, then you get a patent granted, despite you have quite a lot of non-technical characters in. So everything, and this sounds very trivial, which does not contribute to the solution of a technical problem, cannot contribute to an inventive step. It sounds very logic. Nevertheless, we observe sometimes that this is simply forgotten in a patent application to write down. You sometimes have sufficient technical information into it, technical features, which perfectly pass the first hurdle, but when reading the specification, no one knows for what they are responsible for. What are they doing? And this is one of the issues also in the EPC procedure, because EPC is very, very strict with respect to amendments. we are very, very hard by saying the invention has to be made at the time of filing, and it has to be disclosed at that time and not later. So we're very strict to allow you to add significant information later which you haven't disclosed in the originally filed application for a patent. And then if you are left over with a feature of technical character, but we don't find in the specification what this feature is responsible for, you simply might lose the case because it does not contribute to the solution of a technical problem and is therefore not inventive. Thus, the strict advice is, whatever kind of technical feature you have in a CRI invention, think always, what is this feature responsible for? What is it doing? What effect might it cause over a piece of prior art? And if you don't know about it, then maybe it would be better not to use this feature to install technicality, because you just passed the first hurdle and then you are so-called in a kind of a trap, because, and that is the most dangerous, if that what remains is non-technical, you are simply back to a business method or something like that. And it's what I said, and I say always the time, it's also a matter of presentation of an invention. You never claim the invention. You never know the invention. Theoretically, you have always a model to describe it. And the model to describe it might be a different one. There might be a way to describe an invention in business terms. Yes, of course, you want to sell it, therefore you describe it in business terms. There might but also be a way to describe it in technical terms. You can describe it in literally nice forms using art. Yes, but please describe it in technical forms. So try to describe your invention as technical as possible. I always like to look away, not to take away the specifically or the miracle about computer-implemented invention. We always think that it's something wonderful and something completely different from the rest of the world. I tell you honestly, no, it is not. No one inventing a car which can drive faster will say, my car drives faster because I want to sell it. The problem is I want to sell more cars, therefore I make it faster. No. They would never come off the idea to say that. They will say it is faster because I managed to come from point A to point B in a shorter time. I manage it is faster because it is safer when I bypass other cars. They never say it because I can sell it better. I don't know if someone working in car industry here, the only trigger, I'm sure, why you make cars running faster is because you want to sell them. So when you think about your CRI inventions, have that please in mind. Of course you want to sell it, of course, but describe it in technical terms what you want to sell it. And I'm happy that we heard in the beginning here about the feature of financial transaction or things like that. Yes. What is the difference between sending financial transaction from one computer to another one to sending signals? Signals are technical. Financial transactions might be considered as not technical. When you look at your invention, when you make transmission of financial transactions, in what form are they, please? Signals, of course. So I would rather recommend concentrate on the technical description and say signals. And then somewhere, if absolutely necessary, at the very unimportant place of a description, you might write that those signals can, of course, be financial data or financial transaction data or things like that. But concentrate on the technical description, signals. Another issue I have, sometimes if you go to this fintech area, as a tip to give you, well, when you claim signals, you're of course much broader than when you claim just financial transaction. On the other hand, do you really have something in hand when your patent refers to a process of transferring signal or financial transactions which are not secured, for instance, in the form of being encrypted? Everyone working in financial company will say, no, of course not. All law regulations require us that the data is encrypted. So, why do you need patent protection for non-encrypted transmission of financial data? As soon as you encrypt them and make them safe, you're what? You're of course technical. Making a transaction more secure is simply technical. And then you pass the first hurdle, and then you may have a story about the security system. You may have a story about what is particular by transferring the signals. And once you have the story, you are in the question of, do you solve a technical problem in an unobvious way? Last, to come to an end, the very end is then that, is how do you know when I go back? You might now say, well, it's nice, but I don't know the closest prior art. So it will be very, very elaborate to write about each and every possible technical feature, the so-called story. What do we have as difference in the story technically about it? Well, I tell you, first of all, very often you know the closest prior art about because you're expert in your field. Second, and this is a service you have particularly from the EPO, you only pay for one search from the EPO. It might be a high price for the search, but you can have as many searches you want for the same costs. As soon as you withdraw your application, it getting published, you can use the search report, rework your application, file it again, and say, I have already a search report, see here, and then you have a very high chance to get the search fee refunded. So in fact, you can take a search report during PCT, during the first filing at the EPO, if you do that, withdraw it within the priority year, adapt the specification to the closest prior art, and then I say, what can be this adaptation? You add the story. You say, okay, as technical feature over this prior art remains that one. And then you can say, this is solving this problem which was unexpected. This you can add. And the risk is, the highest risk that you have is that you lose the priority date, but you keep the filing date. And this is a rather low risk. So there are ways and means that you even know which is the closest prior art over which you have to distinguish your application in a technical way with technical description of the features. At the end now, our guidelines are published. These guidelines have an index for computer implemented invention, and in the last update round we have added examples, and this was also completely new, I think, for a patent office. We added positive examples. So we wrote in the guidelines what you can have and not only what you cannot have. And this could be a considerable help in drafting your applications. Thank you.
Thank you very much, Georg. I think that was most useful. I think it really gives some great guidance. Before I give over to Bijou, which I know there's a question at the back. I'll give out. Okay, fantastic. Let's get them. Yeah.
The question was with respect to the EPO CII proceedings with respect to applications. So in some cases, what I find is that, especially in the emerging technology areas like AI, blockchain, and so on, we find that the examiners cannot establish a prior art. But they still want to argue, saying that, okay, the steps A, B, C are in the document D1, and then E, D, E, and F is the common knowledge. without any evidence. And this is not one or two cases. I have found plenty of the cases where, as I discussed over 2 days, that there are good sites of expedited examination at the EPO, so I don't want to say that EPO is not doing a good work. I acknowledge that they are doing a good work, but there are certain cases where we are clueless that how exactly to adopt a problem solution approach when somebody is saying, okay, this is a common knowledge without showing us the evidence. Can you throw some light on that?
Yeah, well, is not obliged on the first hand to say if something is completely trivial or considered as completely trivial by him to file a piece of evidence. He is, however, encouraged to do so. And the case law is rather clear, also the guidelines is, as soon as you reasonably doubt that this is general technical knowledge, he has to provide an evidence for this. If he is not doing that and you have the impression that is not done correctly, I always say, and very openly, the EPO has a very, very stringent quality monitoring and measuring system. And whenever you raise an objection which looks like, even don't mention the word complaint, we will treat it in our complaints department and there will be a feedback of it. Important is, the examiner has to properly and orderly reason it, and he cannot say, I don't like a feature, I don't find it, and therefore it's general technical knowledge. No, please address back in an appropriate way. Appropriate ways can be twofold. You may first try to discuss it with the examiner, take the phone and talk to him, and normally they are very, very prepared and willing to phone. You may address to the head of the department, or you may address a DPO complaints form. In any end, it will end up at the head of the department. He will have to look at it to write the position. The complaints and quality department will look at it, and we will get the reply. Those replies are not seen negative. It's not punishing an examiner. No, we use it to improve quality. We use it to spot areas of training, and in particular, when you mention blockchain, I very much feel with you, because blockchain is mainly treated in my department, and we recently had 2 complaints, but the issue was, it was not seen at the EPO that these were blockchain inventions, because a very well-known company based in Germany does not write blockchain in its blockchain applications. They describe it with some different words. I think you even don't write distributed ledger, you write something else. And then the application ended up by accident or error. So when you don't help us, you don't help us, in the area of databases. So the examiner dealing with databases didn't know that it is blockchain, so he cited the document which was just databases, and that would make the difference to a normal database or distributed database. He said, well, that's general knowledge. This was, of course, wrong, and he shouldn't have done it, but at the end we managed to correct it, and in this case we took back the search report with the first communication and issued the correct and second one, where we then had the more competent department dealing with it with blockchains. So complaints might help. But I'm very happy about your question, because it also shows you should also help. Yep. When you, for instance, disguise a technicality, then you might be successful. So when you don't write, for instance, blockchain or at least distributed ledger, which is the better term when I take one of your examples, in the application documents, you risk that you are successful in such a way that we don't recognize that it is a distributed ledger or blockchain application, and then will come in another department. And the other department might then be less competent and not realizing that they should send it to someone else. So you were successful on one hand, but you were not successful on the other hand, because you will not get the best search we can do, and you might get then a strange communication. But the issue is, please try to solve it. either with the examiner, with the complaints department, the head of the department, and they're all willing to help and to solve such issues.
I just want